Good afternoon, Your Honor. Mel Laverne on behalf of Mr. Horton. I applied for my appearance. I came straight from the doctor's office to the jail. If you like, I could go and hurry up and change. Again, I apologize for my appearance.
That doesn't bother me one bit. Just hang tight 1 second, Mr. Laverne, and I'll be with you in just a second. And might want to, I'm not sure exactly where the microphones are in there, but I can tell you right now that it's kind of quiet. So maybe try to get as close as you can under that microphone as you can so I can hear you. And try it again.
Is this better, Your Honor?
That is much better, yes, thank you. All right.
Excuse me, Judge, I'm sorry. I didn't know if we were handling position 8 now. I brought the victim in. Would you like for me to put the victim back in the waiting room?
No, that's fine.
Okay.
We can do 8 first. Deputies, was there anybody else you wanted me to take first today?
No, Your Honor.
Okay, thank you.
And Your Honor,
Yes.
or Madam Clerk, I do believe DA Boston's in the waiting room. If there's any chance she could be allowed in, just to observe.
I do have her. Thank you, Attorney Trent. I didn't see her at first. Thank you again. Sorry about that. Okay, Your Honor, I think everybody is here that's supposed to be here for this position. Thank you, Attorney Tran.
And Ms. Trin, I believe Ms. Ford said that we had an alleged victim in on this case. I didn't see it on your list, but I just want to make sure we have it. Okay, yes, I see her on the screen. Okay. All right. All right. Dr. Horton?
Yes, sir.
We're here on case number 26004494. That encompasses 2 warrants this afternoon, one being aggravated assault strangulation, and the second being cruelty to children in the 3rd degree. Mr. Laverne, you had the opportunity to review the warrants with your client. Do you waive formal reading?
Yes, Judge. We wait for formal reading.
Okay. All right. As the bond, I'm showing no previous Georgia criminal history. There are 2 cases out of the FBI currently pending from October of last year. Ms. Trin, what's your position on bond?
Honor, to start off, we do have our victim present, Your Honor. Apologize, Your Honor. I had a little bit of a hiccup. I do apologize. Your Honor, our victim is present, Your Honor, Ms. Horton. She does wish to address the court on bond today, Your Honor. The state does intend to call her. One of our first concerns, Your Honor, is his criminal history. He has those pending cases out of the state of Illinois, as Your Honor mentioned. It's very recent, Your Honor. It's from October 23rd of 2025. He'd be out on bond for that. They are related to fraud, but appears, Your Honor, from his criminal history, he doesn't appear to have very much Georgia criminal history, Your Honor, but his ties do appear to be much stronger in the state of Illinois from his criminal history. In addition, Your Honor, our concerns are the facts and allegations of this case. We do believe under the Olive factors that he's a significant risk to intimidate this witness, Your Honor, and that he's a danger to persons or property. Given the facts, Your Honor, they are alleging in the facts that the defendant and the victim, Your Honor, they are married. It's our understanding that they live in the same residence. Just to also add some additional facts that aren't outlined in the warrant, Your Honor. I do believe this started off as an argument in their home, Your Honor. They were arguing about the defendant potentially taking the children out to a children's establishment, Judge. That is when the argument started. Functionally, Your Honor, what then resorted or what ultimately occurred is the defendant chokes the victim, Your Honor. The victim, during the incident or immediately after the incident, she discloses to officers that she was choked for approximately 10 seconds and that she almost lost consciousness due to the choking pressure. Whenever officers were able to interview the defendant, Your Honor, he also admits to grabbing her by the neck or pushing against her neck. He admits to doing that for approximately 3 seconds, Your Honor. That is the state's concern. Their proximity and closeness, their relationship, the way they are arranged and living together, Your Honor. Not only that, there were 2 children present in this home, Your Honor. I believe the warrant only alleges 1, but there were 2 children actually present in the home, Your Honor, at the time. A 5-year-old child, their 5-year-old child actually was interviewed, and he also disclosed to officers that he saw the defendant choke the victim and push her towards the wall. That is why we have such strong concerns about her safety, Your Honor, and the potential risk of intimidating this witness. She does wish to address the court, Your Honor, as we mentioned. Her wish is going to be that Your Honor grant bond and that you do believe that you allow her contact with him, Your Honor. Our recommendation is extremely opposite of that. Ultimately, Your Honor, my recommendation is going to be that Your Honor deny bond, and then if Your Honor is inclined to grant bond, we would be asking for several conditions of bond, but at this time, Your Honor, or at the appropriate time, we would ask that we be allowed to question Ms. Horton, or that she be allowed to give her statement to the court.
Okay. Ms. Trin, do you have any issue with the way I typically do it, which is just allow her to make a statement narrowly tailored to the bond issue, or are you wanting to do a direct on this?
Your Honor, I wouldn't have any issues with that as long as, if Your Honor wouldn't mind me following up with any questions in case she just doesn't cover any specific concerns that we might have, specifically in regards to the living arrangements, Your Honor, their contact and things like that.
I don't have any issue with that. I'll give it a shot myself, and if you're uncomfortable with anything else, that's fine. Mr. Laverne, is that okay by you?
That's fine with me, Your Honor.
Okay, I will probably just allow her to go ahead and speak to give you some context for you to make your argument, and then I'll allow you to argue as to bond as well, okay?
Thank you, Judge.
All right. Let's see, where did she go? Mrs. Horton, do you mind turning on your video, please? Okay. Good afternoon, Ms. Horton. I'm Judge Johnson Gage. I'm going to be presiding over this proceeding today. Do you mind raising your right hand, please?
Yes.
Do you swear affirm any testimony you may give in this matter be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. And can you state your name for the record, please?
Christiane Horton.
All right. Ms. Horton, I'm going to allow you to make a statement, as you are entitled to, as the bond today. I'd like to keep it narrowly tailored to that issue, all right? So the question is whether you are okay with or opposed to bond, and any concerns you might have in that regard, any conditions you might want if a bond is granted. I'd prefer you not go into the allegations themselves or anything having to do with what's alleged here. Just keep it to the matter of bond. If we start to stray outside that, I might try to rein things back in, all right?
Okay.
Go ahead.
Your Honor, I would appreciate if you could grant him bond in the sense of I need my children to have their father here in the home. Even in the moment that things were escalating, I was never fearful for my life. My children were never in danger. He is under a tremendous amount of stress, and I believe that it just came to a bubble. And I was not the one to make the phone call. For our home to properly run, I want him to be here. I just knowing who he is, I know he's very remorseful, and that this would never happen again. It has never happened, period. He's not a violent person. I just feel like he is under a lot of stress, and I would just be so thankful if you would grant him bonds in the sense of him being able to be here in our home.
In the event that I do grant bond, Mrs. Horton, what are your feelings? It sounds like I know the answer already, but as to the contact with Dr. Horton, what are your feelings with that?
Yes, I would want to have contact with him, and I would want my children to have contact with him. And then I would also like to say that in the midst of these past couple days, I have been in the process of getting a counselor lined up for him and for us as a family, because I know that's needed. But I definitely want to have the contact for myself and for our family.
Are there any firearms in the home, Mrs.
No,
Horton?
sir. No, Your Honor.
All right, Ms. Trent, any follow-up questions that you had?
Ms. Horton, I know at the time, or it's alleged at the time, you didn't seek any medical treatment. Have you gotten any medical treatment since then?
I have not.
No further questions from this, or actually, Your Honor. And Ms. Horton, I know you would like contact if the judge is to grant bond. Is that also your intention to potentially have him live in the home with you?
Yes, ma'am.
No further questions from the state, Your Honor.
Were there any questions you had, Mr. O'Byrne?
Just a few follow-up questions, Your Honor.
Okay, let's keep it to bond, please.
Okay. Good afternoon, Ms. Horton. I just wanted to clarify a few things. So, if the judge were to grant bond, no violent contact?
Sorry, well, can you repeat? I'm sorry.
Can you hear me?
Yes, I'm
She asked
turning
you
on.
to repeat.
Oh, your position is that if the judge does grant bond, you're asking for no violent contact provision in that bond instead of no contact at all.
Yes, correct. No violent contact.
And the state, and I'm sure the judge, they're concerned about your own personal safety. And from what I'm gathering, is that you have no concerns that Mr. Horton would pose any threat to you or your family if he was allowed back in home. There's no violent contact provision.
No concerns at all. None.
Okay. No further questions, John.
Any follow-up to that, Ms. Trent?
No follow-up, Your Honor.
Okay. All right, Mrs. Horton, thank you very much. I'll allow you, if you don't mind, just putting yourself on mute again. You can stay on video or off, doesn't matter to me. All right. Was there anything you wanted to add as to argument, Ms. Trent, or otherwise I'll turn to Mr. Laverne?
Yes, Your Honor. And Your Honor, again, the state's recommendation is that Your Honor deny bond. What you didn't hear today, Your Honor, during the victim's statement was any denial today of what occurred. And I understand bond is not meant to punish Your Honor. But again, her wish, Your Honor, is to have contact with this defendant and for him to potentially return back into this home. Again, under the IL factors, Your Honor, the state's concern is the potential risk to intimidate this witness pending trial and the potential harm and danger to the community he poses if he's released out on bond. If Your Honor is inclined to grant bond, we would be asking for several special conditions. Those conditions would include no contact with the victim and no firearms while on bond, since it is a domestic violence incident.
Okay, Mr. Laverne?
Thank you, Your Honor. Dr. Horton is 48 years old. He resides in Georgia. He was formerly the DeKalb County Superintendent. He recently had to resign from that job, so he has ties to the communities. He is not a flight risk. He has no prior bench warrants. He has no prior convictions. I do understand that it was brought up. He may have an open case, however. Mr. Horton, Dr. Horton does maintain the presumption of innocence. He has not been convicted, nor he has pled guilty in that open case. Lastly, Judge, we heard from the victim herself. She is not fearful of Dr. Horton, and she also claimed that during this incident, she never feared for her life once. Judge, I do believe that Dr. Horton is a great candidate for bond. We do believe that a reasonable bond should be set. We're asking for a bond in the amount of $5,000. Mr. Horton, again, is not a flight risk. He has ties to the communities. He's not a danger, and furthermore, he is not at risk of committing any additional felonies. We have not heard any evidence of any prior convictions, any evidence that he's a flight risk, has failed to appear to court, And furthermore, is only an other case is an open case which he has not been convicted of. So for those reasons, Your Honor, including the statements that the alleged victim gave his wife, bond should be set, and we're requesting a bond in the amount of $5,000.
Okay, thank you.
With no bond contact provisions, Your Honor.
Just one moment. All right, Dr. Horton, Mrs. Horton, I will note Dr. Horton, your relative lack of criminal history, no violent criminal history at all. I think under those circumstances, bond is appropriate in the case. However, as I mentioned, there are a number of things I consider in setting bond. One of those is the totality of the circumstances surrounding your arrest. And whenever you're talking about allegations of putting your hands around someone's neck, that offers a lot of concern. It does not take much pressure before something worse can happen. And so that's going to be in the forefront of my mind in setting bond here, and the conditions that are going to be attached is how something as alleged is bad enough as it is, but could certainly be much worse, especially given the stressful situation that you are evidently under. I'm going to set a bond in the amount of $25,000 regular. That'll be $20,000 as to count 1, the aggravated assault, $5,000 as to count 2, the cruelty to children in the 3rd degree. More importantly are going to be the conditions attached to it. As to contact, I understand your concerns, Mrs. Horton, and your wishes here, and I do not want to deviate from those wishes, but the concerns that I mentioned are really at the forefront of my mind, especially as close in time to when this allegation occurred. So while I'm not going to do no contact at all, I am going to impose a no in-person contact provision. You shall have no in-person contact with your wife. You can have contact via telephone, text, or video call, so long as that contact's not violent in nature, doesn't explicitly or implicitly threaten the alleged victim, and is not intended to influence her testimony. I understand, Mrs. Horton, that y'all wanted to engage in some counseling. I hope that allows the opportunity for you to do that by having that kind of contact, the virtual contact. To the extent that you have any firearms, they're to be surrendered within 48 hours of your release. You shall not purchase nor possess firearms while you're on bond, and I am going to have you report to pretrial services within 24 hours of your release to make sure that those conditions are followed. You shall not violate the laws of any governmental entity, and you shall make all future court appearances in this case. To the extent that the contact provision causes issues with any personal possessions you might need, I'll give you 1 trip with police officer escort to retrieve those possessions. That'll be the order.
Yep, Judge, can I just clarify? They do have 2 children. I understand this for clarification for my client. The no in-person contact is solely between Dr. Horton and his wife. He gets to have contact with the kids. Thank you.
That's correct, yes. Any exchanges with the children or whatever just need to be arranged through a third party. All right, anything else on this case?
Yes,
No, Your Honor.
excuse me, Judge, give me the breakdown again, please.
Yes, $20,000 as to count 1, that's the aggravated assault, and $5,000 as to count 2, that is the cruelty to children in the 3rd degree.
Thank you, Judge.
All right. Thank you, Mrs. Horton. You have a great day. And what, did he sign, Miss Ford?
Yes, he did.
Okay, great. All right. All right, my intention next is to do the SCOs.